My lord, there are 3, not 2. Actually 4.
But they say the same thing. They say they want to. If there are 2.
Yes, my lord, in response to the application by my learned friend, Mr. Ochel, future senior counsel, and my learned friend, Mr. Ndegwa Njiro, I wish to say that follows. My lord, number 1, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number 1, my lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number 1. My lord, point number 2. Ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore, or the applications made are therefore res judicata, in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number 3, my lord. My lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my lord, the qualifications of the Deputy President nominee, Kindiki, can only be brought to this court, my lord, through 1, either a new petition and a new application, or 2, my lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are application through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application of conservative order. So that's a negative order. And the court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimodo and Company Advocates from Kerugoya, who has also sought to stay your orders. Yet, all that application had, my lord, was for the former Deputy President
to apologize.
Former underlined, to apologize to NIS. Surely, Kimodo, you can do better. My lord, I invite my friend.
You are protected. You are protected.
Right, this is Kimodo and company.
Yes, my lord, my name is Mudhomi Thienkolu for the second interested party. I have listened very keenly to the 2 applications.
Let's see what to say.
And the issues for you to weigh in your mind are as follows. 1, if the outcome they seek through these 2 applications was declined by the Court of Appeal, not yesterday, but today morning, Can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that results in the very outcome?
May I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let's submit on the premises of facts and not the premises of presumptions and the intentions to mislead.
It was declined. It was declined. Application for stay was declined.
My lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications.
Yeah.
That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
Another application was made. Properly.
My lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which we would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had notice for several days. If they have any issues with the suitability, they would have filed an application on that regard or even amended the applications we just determined, and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Madhu paper this and that. Two. Number three, my lord, what you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course, there is a possibility, my lords, you're in error. But there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about the Madhu paper, injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests. And conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, I said this court has jurisdiction, if eventually you find that the Honorable Rigathi Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
Thank you.
My lord, if I use only 2 minutes.